Good afternoon, and thank you very much for coming to the 5 St Andrews Hill seminar on making the most of experts in fitness to practice proceedings, and along with that, a case law update. This webinar is being recorded and it will be available on the 5 St Andrews Hill YouTube page for those of you who wish to catch it later or can't catch all of it. Or wish colleagues to look at it. And in addition, these slides are going to be available after the event for those who wish to have them. The case law update is going to be provided by my colleague, Amy Woolfson. She has a rapidly expanding regulatory practice. She appears regularly for regulators such as the HCPC and the NMC, as well as acting for registrants before the General Medical Council and elsewhere. I'm a barrister who has specialised in fitness to practice work for some 15 years or so now, working for a time in-house at the General Dental Council and later spending 12 years or so at Blake Morgan Solicitors, where some of those attending today may well know me from, before moving into self-employed independent practice here at 5 St Andrews Hill. I act regularly for a wide variety of regulators and have done in the past, as well as acting for registrants both before healthcare regulators and other regulators, such as in the fields of accountancy and education. We are joined here today by someone who may be familiar to those of you who practice in proceedings before the General Dental Council, and that is Abhi Pal. For those of you unfamiliar with Abhi, he is a general dental practitioner who practices in Birmingham. He has some 20 years experience of providing clinical assessments and reports, giving evidence both at courts in clinical negligence proceedings and at fitness to practice hearings at the General Dental Council. He's been giving evidence in fitness to practice proceedings for approximately 12 years, acting regularly for both the defence and for the GDC in the most complex cases which are brought before those committees. He was until recently, until it ceased to exist, the Dean of the Faculty of General Dental Practice UK and is the first elected President of the College of General Dentistry. And indeed, he is very active indeed in the wider dental profession. Questions are welcomed and can please be asked at any time, but we will deal with those at the end of both presentations. Dealing with my presentation, which is going to be about adducing effective expert evidence. It is intended to be a little bit different from the way in which many seminars are approached, which is to hear from the lawyer and for the lawyer to set out in detail what the law is and what their views are of how best to achieve what it is that lawyers wish to achieve, be it those acting for regulators or those acting on behalf of the registrants. Sometimes what is not heard, however, and certainly it has been my experience that it's a voice not heard, is the voice of the experts themselves. We all know, those of us who practice in this area, how important expert evidence is in fitness to practice cases where some or all of the allegations are clinical allegations. And it is therefore to that effect that we have Abhi here, who is going to share with us some of his experience about what it is that we as lawyers can do better to assist experts in being able to give of their best in the evidence that they give in fitness to practice proceedings. What I don't intend to do in my presentation is to seek to go through elementary principles of law or things of that nature. I'm conscious that many of those who have signed up to this webinar are people who have been practicing in this area for many years and know the law very well, and I'm sure it would be of little value to you for me simply to tell you that which you already know very well. Instead, I hope it will be an opportunity, a useful opportunity for us to explore with Abhi what best assists experts, and also for you to ask questions of him that deal with any particular issues which come to mind during the course of our talk. And because of the relatively limited time, whilst you will see a slideshow, I won't be taking you through each and every point that is made in the slides. They are there as an aide-memoire for those of you who have attended the seminar, and I hope provide a useful summary of the points that I anticipate are likely to arise. The topics which we're going to be covering today, in turn, albeit some with more depth than others, are going to be firstly instructing the right expert, secondly how to draft instructions, thirdly conferencing with experts, for the reports themselves, fifthly joint reports, and finally issues that can arise at hearing. So firstly, dealing with instructing the right expert. All of us know, who practice in this area, the importance of choosing the right expert and the legal principles that apply to that. And one of the key questions is always going to be, is the expert someone who has the right expertise? In part, we're informed by the expert's own view of whether or not the matter we're asking them to opine on is within their area of expertise. Abhi, from your perspective, what best assists you as an expert, and particularly considering now experts who are a bit less experienced than you are, in determining whether or not you feel you have the relevant expertise to be able to give the opinion you're being asked to give?
Yes, thank you, Guy, and good afternoon, everybody. I think to get a clear picture as what the clinical situation is will help an expert to, of course, know whether they carry the right skill set in order to be able to give an opinion on it. Clearly, before the instructions arrive at the expert hasn't got a chance to see the material, the notes and everything. They're reliant very much on the initial instruction, laying out what the situation is, what kind of care has been provided, what kind of practitioner provided it. As much information as possible in that initial approach is certainly going to help the expert to realize, whether they have the right skill set or not. And of course, because I was saying, experts shouldn't be opining on things that's outside their skill set.
And when you're talking about the initial approach, you effectively mean that email that comes through saying,
correct,
we have this matter, we'd like to consider you instructing on, is this something which you'd be able to assist with?
Correct, yes. And I think it's worthwhile giving a little bit more background in that so that the expert knows that, well, these are the issues that are in contention, and they can weigh up whether their experience matches what is required.
Let's move on to dealing with the question of providing you with instructions and what should be in those instructions when we get to the stage where instructions have been accepted by the expert. Clearly, as I've already said, the expert is key in a lot of these cases, and the instructions document that is sent to you is going to be, would you agree, critical in shaping not only how the case is going to be run, but key to you as an expert in understanding the expectations of you and ensuring that you produce a report that's going to be of forensic assistance. What to you are the key things that you need to be provided with? And again, thinking back perhaps to earlier times in your practice, in your instructions to ensure that you're providing the right support to the lawyers.
Yes, of course. The instructions are now fairly, and we're talking initially about prosecution instructions because I think we'll be going on to defense instructions in a bit. So in terms of prosecution instructions, I think they're pretty much standardized now as they come from the regulator in containing the background, the documents, and directing us to what the areas are that we need to address. Of course, one of the things that experts from the prosecuting instructions aren't always aware is the fact that their report will be used to draft the allegations themselves. And the report will be used to support allegations that are being drafted later. And of course, it's a matter for lawyers, of course, to draft those allegations, but the expert should be directed to take a good look at those allegations and make sure that they actually match up to what their opinions are.
Do you think it's always easy to understand the precision with which those allegations need to be crafted and the significance of each and every word being accurate within those allegations and how your reports can impact on that?
Well, unfortunately, I don't think that's always in the mind of experts when it's drafted. It's sometimes, unfortunately, when they're giving evidence that it dawns on them, unfortunately, that actually the wording on that allegation doesn't precisely match up with my report. And I think it's something that could be made a little bit clearer to experts at the outset. And
something that can be reinforced in conference, presumably, as well.
Indeed. I can remember in the past, allegations coming back, and so myself being asked to look at them and only a glance over them, and then realizing later what the importance of that is. So yes, that can all be reinforced.
And in terms of disclosure and the possibility of disclosure of what you as an expert have committed, not only in previous drafts of your report, but also things you have said in correspondence or said in even telephone calls with other lawyers.
Yes, this again is not something that is often in the minds of experts as they go through the report and the instructions, that every single phone call, conversation, email is disclosable. And indeed, more importantly, I suppose, each draft of the report. And as they change, as an expert changes their opinion, there should be a valid reason for why that opinion is being changed, because again, it becomes difficult if it's only realized at the hearing stage, while they understand that they have to account for changes and communications that they had before. So yeah, I think it needs to be made clear to certainly prosecution experts the importance of that disclosure.
Would it be fair to say a key thing that's going to come out throughout all of this is probably going to be the importance of an expert getting things right as soon as possible and giving good and proper consideration to the issues they're asked to look at right from the very beginning, so that things don't go awry further down the line?
Yes, I mean, my experience is that the basis on which the case is made is reliant on the expert's opinion. And it's important for experts to know that they get the whole opinion in at the beginning, because again, it's an issue of being challenged. When you're challenged on your opinion, if experts then start to expand their opinion and give more than they'd actually put in the report, that could be problematic. So yes, it's always best for the expert to know that right at the outset, the entirety of their view is there. And what the base of that view is. Are they relying on, which in most cases they will be relying on, references or guidance or publications that's there to make sure that ties in with their opinion, and they give that the full account right at the outset.
Certainly we'll be coming on to the structure and what should be included in reports in a little bit. Defence reports and the instructions in respect of those, they're a little bit different, aren't they? What you need to be able to draft a defence report. And would it be fair to say that your role as an expert feels like a very much more reactive one at that stage when you're instructed as a defence expert, as opposed to being instructed by, in your case, the GDC?
Indeed. Ultimately, the opinions will be still in the same way because we're being asked to give an opinion on a situation. But instead of course, making the case from scratch, as we would be with the prosecution, the defence expert is asked to respond to the allegations that are fielded and then go allegation by allegation. So certainly the format is different. The way the case is approached is different. Ultimately, the opinions shouldn't vary on either side, but as we know, they do. And what's also important is the witness statement, because the difference is that with the expert, we've got the registrant there in front of us at conferences. I know defense lawyers struggle sometimes to get the witness statements finalized and sent, but that witness statement is, of course, very important for the expert to be able to, despite what's said in conference, until they know in black and white what the registrant's case is, it can be sometimes difficult to make that final report. And so, yes, we've got in some ways, we've got the same material because it's the same records and everything, but then there's...
You get the response, yes, and more, which the regulator might not have the benefit of at that point. A live issue which, for me, has been there for experts, certainly at the GDC, for time immemorial, has been the vexed issue of what constitutes falling below the standard of care and what constitutes falling far below the standard of care. Now, my experience has been that experts who have been doing this work for a long time, having had the benefit of being challenged and tested by advocates and also by committee members, as well as being challenged in conference, have got pretty good at being able to understand from the lawyers and the committee's perspective what it is that is meant by those terms and what in their minds are the factors that are relevant to their opinion and how they're going to explain in their report how those factors apply. Newer experts, however, seem to struggle with that concept, and often it's the one thing that I find experts will come back and ask for clarification on, and it's not always the easiest thing to put in black and white terms. From your perspective, what has best assisted you in making that transition from not being perhaps entirely 100% comfortable with those terms, if indeed that was the case 12 years ago, to now being actually very comfortable with those terms and having a good set of criteria in your mind and in your reports when you give an opinion on the standard of care?
Well, to answer that question directly, Guy, what has actually allowed me to be a little bit more confident on it is hours in the witness box. Ultimately, that's actually what's allowed me to understand, where those levels are through being challenged on those. It's not, in an entirely satisfactory way, because we would think that, we can, as experts, agree on things. And I think, by and large, there is a level of agreement, but there is still an element of subjectivity about it. And I know prosecutions from my regulator, instructions from my regulator, the GDC, when they come, they sort of try and spell it out a little bit more. They've got 6 points which they put down as to what they suggest may be far below, and I think 3 points which may be below. And I think newer experts can sometimes look at those and just use them in a very narrow, very precise way, which I don't think is always helpful. I think what is helpful is for experts to understand that they should be looking at a more contextual situation, because the same failing, if you like, could be below in a certain context and far below in a different context, depending on how that situation is. And rather than looking at each sort of item of substandard care and looking at it in isolation, I think experts should be encouraged to look at it in a little bit more broader situation of what happened overall, what the clinician's environment was, the situation was, and then make a decision on whether it's below or far below. Obviously, there's reference to standards and guidance, which is out there, but it ought to be remembered. And our college, which just produced some of the guidance which regulators use, has been very clear in saying that this is guidance, and the guidance is there to guide practitioners make specific decisions. And ultimately, what a practitioner does and how a practitioner uses that guidance may be different in different situations, rather than saying, so this kind of contextual element, to get that out, I think would be good. Because defense instructions tend to be a little bit slimmer on advice on below or far below. But, I think they're, again, responding, defense experts are responding to the prosecution experts' own sort of definition of below and far below.
I mean, at this point, it might be useful to move over to conferencing, because this is the sort of thing that can be brought out in conferencing with an expert. It's perhaps not ideal to do so if you're dealing with a regulator's instructed expert, and because it will lead or potentially lead to a change of view, and hopefully the expert will justify that change of view at some point. But in terms of conferencing from my perspective, if I'm acting for a regulator, it's the opportunity, as well as dealing with what further evidence should be obtained to consider whether or not the expert's got all the information they need. It's an opportunity to probe with the expert their opinion, their reasons, whether or not they have considered and included in their report all of the relevant factual scenarios that apply, which is something which often is missing, and opined on them, and ensure that they have done so and included that in the next draft of your report. From your perspective, though, as an expert, what do you find most useful to take place during a conference to ensure that you're producing the report you need to? And again, both, not just when acting for the regulator, but when instructed to act for the defence.
Yes, actually, I think if the lawyers are in any, and of course, lawyers are doing this at conferences, lawyers have any areas of doubt or clarification, to really home it in the conference and get it out. Because I think from an expert's point of view, we would rather have any potential challenge in conference and give ourselves an opportunity to reflect on that, even if it means a alteration of the opinion. I think this can be done in a much controlled way for experts than having to have the same challenge in open hearing, where it can be very unpredictable how the question comes and how you deal with it. So I think it's important for the expert to understand, as they come to these conferences, this is an opportunity to really get the report right, get their opinion right, and any areas of doubt that they have the opportunity to get that sorted out in there. And of course, from the defense side, if those conferences are massively helpful, because usually the preliminary report for the defense is done without the registrant in there, but with the in the conference, with the registrant in place, again, it's important the expert knows that they have a challenge, they have an opportunity to, in some ways, challenge the registrant, but actually get the registrant's view on why certain things happen.
And of course, from an advocate's perspective, when you're in conference, it's an area you're not particularly familiar with. It's an opportunity to get your expert to explain to you how the clinical stuff works, so that you understand what you're dealing with. And some advocates will be far more experienced clinically than others, of course.
Yes, and some advocates are, of course, more interested in finding out about the clinical issues rather than others. And there is a general feeling experts have that, the clinical issues aren't ones that advocates want to, go in too much depth sometimes, because, of course, the issues related to integrity and if it is dishonesty and so forth, they're much more serious. But I think the advocates should use that opportunity to, clear up any kind of doubt or lack of understanding in some of the clinical areas.
Yes, because we're going to have to rely in part on your expertise, with no small part on your expertise, to form the basis of our cross-examination.
Yes.
Moving on to reports, and thinking here in particular about the structure of those reports and what should be included in them, and how we come to get to what both the lawyers and the expert would consider to be a good report. Perhaps we can take this firstly by just looking at defence reports. I presume from your perspective, that's a much easier exercise, because you're being pointed towards the allegations which have been pleaded by the regulator and essentially being asked to comment on those.
Yes. easier, not necessarily more straightforward in some ways, because of the prosecution one, you're doing the groundwork to build or support in building the case. Yes, much more straightforward because you're responding to each allegation as you go along. But, we're having to also find and give the opinion of what no reasonable dentist would do and be confident that that is the case. And if there is an alternative way something could have been dealt with, then, as we structure the defense report, we should be able to give the evidence or the guidance or references why the view is different.
Yes. Looking then at the regulator's report, as you rightly said throughout, this is a document which forms the basis of what the allegations are going to be. So it's not reacting to allegations necessarily that have already been formulated. And I suppose there's two ways in which, or two contexts, isn't there, in which these reports are usually produced. One is a report produced from complete scratch and effectively forming the basis of the criticisms based upon looking at the patient or other source of complaint and looking at the clinical notes and what other material is available to you. And the other context, which I think more commonly you're instructed on, is when there has been a referral already made in a non-front-loaded case by a regulator, where further investigation is going to have to take place, and a decision has been made to refer on the basis of certain particularized allegations. Now, I have a view, certainly from an advocate's perspective, and what I find easiest when it comes to drafting charges and presenting the case, that what assists me best is an expert report that deals with the care effectively chronologically, goes through each appointment, sets out what happened at that appointment, what went right, what didn't go right, where there's criticism, where there's not, and deals with it if there's multiple patients, as often there can be in cases, effectively patient by patient, and then deals, if it needs to, elsewhere with other discrete issues which come up, because then it makes it issue to align your allegations as you draft them with the report, and it's easier to take the panel through that report alongside the allegations. And for my part, I think it makes for easier presentation of the case, but that may not necessarily fit sometimes in the way in which you're instructed, if you're instructed in a more thematic way. For you as an expert, what do you find the easiest approach to drafting a report, looked at in the context in which you're getting instructions from the GDC?
Yes, I think it's usually easier to be given the freedom to be able to, if you like, create the report from scratch in looking at the totality of care. I think being asked to, on the prosecution side, pre-particularized allegations and then have to deal with those, I think does constrain an expert. It is far easier to look at the totality of care, look at just in the way you've described, lay out the chronology, and then in a logical manner go along the patient's journey, if you like, and what things went wrong, where, and for what reason, in a logical manner, and then allow the lawyer to then draw out further particularizations there. If, as a prosecution expert, I've already been given certain particularizations, and bear in mind, in some situations, we haven't been given access to perhaps the base report that led to those particularizations, for reasons which I fully understand, of course, because there's a separate set of evidence there. I think this, just being asked to deal with these can constrain an expert in being able to fully give an opinion. So yeah, always easier, I feel, for the expert to be given a little bit of a, not carte blanche, but obviously in a directed way, the freedom to be able to go through the whole patient's journey and the episode in the way that would be logically laid out.
And of course, the benefit of that is that you're not missing allegations or potential real issues that have arisen in the interim, and you're ensuring that you're not putting yourself as the regulator at risk of under prosecution. moving on then now very briefly to issues arising from joint reports. Now, there's various ways of drafting joint reports, and this will usually come during regulatory proceedings after there's been an opportunity for supplementary reports to be provided by experts. And it's a comparatively recent development, although it's been going for some years in professional regulatory proceedings and not fully necessarily adopted by all regulators, where it's an opportunity for, as we'll all be familiar with, the experts to get together and have a discussion between themselves without lawyers present to see whether or not there's areas of agreement and disagreement, particularize what they are, and set out the reasons. One issue that has risen from my perspective, certainly, and others may share this, is that the reasons that are sometimes given by experts in these reports are less than fulsome, sometimes very much less than fulsome. Where opinions are simply repeated or where there is simple agreement, then there may be good reason for that. But when experts change their view, sometimes those reasons are less than helpful to explain why there's been a change in view. What do you think can be done, if you agree with that proposition, to assist experts in providing the level of reasons which the lawyers need to decide what steps to take at that point?
Yes, well, first thing is that I think this is a very good development. And you're right, it is one that has come about in more recent years. I can remember in the past, there was no such joint meetings, no such joint report, and everything just got attritionally fought out at the hearing. And we've got less of that now, fortunately. But with the joint report, I think it would be important to direct the experts to give as full a reason as possible where there has been a change of view. I can understand why there would be a reluctance amongst experts to put that in, because any change of view could leave them open to challenge of some sort. But my experience is that if a full and clear view of why opinions have changed, assuming there can be some agreement, is there, it in general makes for a easier hearing, an easier right of the hearing. And again, that could be communicated that, if you genuinely feel that there needs to be a change of opinion, whilst it may not assist the lawyer's case, they should be encouraged to put that in there. Also, there's another issue about these joint reports, which just dawned on me earlier today, is that unlike the main reports, of course, there is no lawyer that is looking at those reports and asking for further clarification.
Yes.
Those two reports are drawn up by the experts, and then they go to the lawyers, and there's usually no possibility of further clarification needed. So again, the experts should be directed to pay a bit more attention. I mean, the time is actually invested in the meeting itself and the writing down of notes. And actually the formulation, the drawing up the report is often, less time invested, if you like.
Yes.
And I think some kind of direction to experts to say that joint report is going to be very important when it comes to hearing, and to spend a little bit more time on that would be helpful.
No, that's helpful to understand. And moving then finally to the issues that can arise at a hearing, which involve an expert. And I'm sure we've all had occasions at hearings where something has arisen that was not anticipated and has to be dealt with within a short time frame without the comfort and convenience of the sort of time that one has available, for example, in a conference. The classic one for me that can come up is where there's been a change in view by the expert. And usually we're talking here the regulator's expert prior to them starting to give evidence. Now, obviously, you'll be well familiar with your duty to make known to the lawyers that you've formed a change in view. And perhaps as an aside, I'm not always convinced that every expert is entirely familiar with that. And it may well be worth reminding less experienced experts that is an important duty, as indeed their duty to say if they feel for whatever reason they're no longer able to give evidence which is within their area of expertise. But let's say something comes up at a hearing, as it can do, for example, in cross-examination, it's not been dealt with in your report and it causes a change of view. One would expect a supplementary report to be provided at that point, and that the experts provided with facilities to be able to produce one. What advice should one give to experts at an earlier stage in proceedings who aren't necessarily used to having that thrust upon them at the last minute?
Yes, I mean, if you're talking about evidence being just put to the expert in the form of written references or guidance, as has happened to myself and has also happened while I've been on the defense to my opponent on the other side, I think the experts should be informed that they can take the time they need to understand that new evidence before they, give an opinion. They shouldn't obviously have to just do it on the spur if they're not sure. If an opinion is changed, then again, the expert should be, encouraged to give a clear reason why it has, and provide a report.
Presumably something as simple as make sure you bring your laptop to the hearing.
Well, actually, I mean, which is another matter. I think there ought to be some kind of guidance given how they're going to look at, because most of the evidence now is happening electronically and not on paper.
Yes, well,
and I think IT is another
maybe a point for another day.
Maybe a point for another day, but they ought to have a degree of skill in that.
Before we now move on to Amy to give her thoughts on recent case law, Abhi, any other final tips for lawyers instructing you, or more junior experts, or should I say less experienced experts, that you'd like to share?
Just in terms of lawyers, just to be as clear as possible particularly to experts that haven't done this. There's a whole pool of experts out there in my profession who've been doing lots of civil reports and no trial experience on them. It's a step up from doing that to doing regulatory work, and not all experts quite get that because they're not used to, on doing civil reports, used to that degree of challenge that you can expect in regulatory cases. So I think as much information as possible about the process would be really helpful. I think new experts should be encouraged to actually see parts of a hearing. And nowadays, the hearing is, of course, remote. And finally, I think the issue of expert training has to be addressed by both the professions and the lawyers as well.
Yes. Abhi, thank you very much for your insights. I hope they've been helpful to those attending the webinar. And Amy, now would you please like to take us through some of the recent case law you're going to talk to us about?
Thanks very much, Guy. Thanks, Abhi. That was really illuminating. My name's Amy Woolfson. I'm going to be taking you through an update of recent case law. In terms of the selection, Tess, if you could just bring up the next slide, please. Thank you. These are the topics that I plan to cover. They're hopefully in alphabetical order. It's not intended to be a completely definitive list of recent cases, but more a helpful overview, cases from the last 9 to 12 months. I've grouped them by topic. I've put in Bailey links to each case, and I'm not going to give you the lowdown on the facts or the reasoning in every single one of those cases, although if you'd like to test me in the questions, you're welcome to have a go. But what I will do is just highlight a few cases which I think are quite interesting. So firstly, in terms of abuse of process, thank you. This case really deals with when it may be an abuse to have regulatory proceedings which cover a lot of the same ground as previous proceedings in a court or tribunal. And the answer is not that often. So in this case, Mr. Davies made a complaint that Mr. Green had been dishonest and had misled the court. And Mr. Green, in his defence, said, well, you ran that argument in our civil dispute and the court was against you. And the Court of Appeal said that may well be the case, but the purpose of regulatory proceedings is much broader than any test that would have been applied in the civil proceedings, and there are wider public interest considerations. That case also gives quite a helpful lowdown on other similar cases where you might have a decision in a criminal court, in family proceedings, etc., and what weight, if anything, the decisions in those proceedings might take. I would also refer there, and this comes up in the evidence section of my slides, to the case of Gray and the SRA, which was kind of the converse, in that Mr. Gray was very heavily criticised by Mr. Justice Flo in the course of commercial court proceedings, and various findings were made on the balance of probabilities. He was then brought before his regulator. The relevant standard of proof at the time was the criminal standard, and he essentially argued that the court had put too much weight on those civil findings. In terms of Ray and the GOC, this is a case where a conviction ended in a conditional discharge, and the courts and the regulator got in a bit of difficulty over the precise effect of a conditional discharge. Well, the effect of a discharge is as though it was not a conviction at all. So you can't bring conviction-based proceedings against a registrant who has been given a conditional or an absolute discharge. That's very helpful for those of us who defend regulated professionals in criminal proceedings, and it's something certainly to bear in mind throughout those criminal proceedings. In Ray, though, the court also said that whilst you'd have to bring misconduct proceedings against a registrant who was given a conditional discharge, if they had pleaded guilty to the offence for which they were given the discharge, then their plea would be evidence that they accepted the behaviour upon which the misconduct might be founded. If we can move to the next slide, this is a costs case. It's one in which the SRA were given permission to intervene. It was about the power to award costs in the Competition and Markets Tribunal. And essentially, the Supreme Court said, well, there's a distinction in terms of awarding costs between regulators like the CMA, which are funded effectively by the Treasury, and regulators such as the SRA, which are funded through their largely through membership fees. And what the court said is, whilst they accepted there could be a chilling effect in some circumstances, there's not necessarily going to be a chilling effect, whereas in a regulator like the CMA, they're a large regulator, they have a lot of resources, and in fact, they only bring very few cases. If we could just move on to the next slide, please. Lots of cases on dishonesty. The first three on that slide are all evidence of the MPTS and also the High Court grappling with a registrant who may not have had a finding of dishonesty made against him, but may have seemed dishonest in their defence of the charge, or where they've simply robustly defended an allegation and it's been suggested that that equates with a lack of insight, which it does not. So that's those three cases at the top there. The case of Nazari and the SRA, I think this one is interesting. It's just a couple of weeks old, and it deals with a solicitor who had been misusing a blue badge. He'd gone on trial for the fraudulent use of the blue badge in parking and so forth, and he'd been found guilty, and it had been brought as a conviction case. And there were two grounds of appeal, both of which were dismissed. Firstly, Mr. Nazari said, well, when the investigator wrote their report, they recommended that this case be disposed of by way of a financial penalty. So how can it be right that when this goes to a tribunal, I end up being struck off? And the High Court didn't have really any time for that. They said, well, an investigator is entitled to come to a view, but they're not the tribunal, and their view can't possibly bind the tribunal. The other point there was the effect of dishonesty. Mr. Nazari argued that it wasn't the most serious dishonesty, and it shouldn't lead to a strike-off. And the court was quite clear that certainly so far as solicitors go, dishonesty is normally going to lead to a strike-off. If we could move to the next slide, please. This is evidence. I've already dealt with Gray and the SRA. I'd highlight Khan simply because it builds on what the court said in Dutta in relation to assessing the credibility of witnesses. Arrow Wojulu, I think, is an interesting case because it deals with what in criminal cases would be termed non-defendant bad character. It was an allegation that the doctor had sexually assaulted a receptionist, and in his defence, he said that because the receptionist had previously made an allegation about a relative sexually abusing her, and that had not resulted in any charges, therefore her character was in question and her propensity to lie was in question. It's a case that had a very unhappy procedural history, but at the end of it, the court said the proper approach is to determine whether the allegation about the non-defendant's conduct is established. And in this case, the court weren't, or rather the MPTS weren't satisfied that there had been a false allegation previously made by the complainant. And then secondly, to consider what the impact would be on their credibility as a whole, and what the MPTS found in Arajulu, and it was not surprisingly, seeing as it was adopting a previous High Court judgment in the same case to be the right approach, was that they then found that, well, frankly, even if she had made up a false allegation about a relative back when she was a teenager, it couldn't really have any bearing on her propensity to tell the truth about what she said had happened with Dr. Arajulu. Next slide, please. Interim orders. MXM, I just raised that because it sets out quite clearly when a registrant can be anonymised in a High Court appeal. White in the GMC, that is the case that you may well be familiar with, where Mr. White was a COVID skeptic and he was made subject to an interim order not to post on social media about COVID. There's a lot of commentary about how Article 10, freedom of expression, and also considering the test for making what's effectively an interim injunction under the Human Rights Act in these sort of cases plays out in the regulatory context. But the thing that I would highlight from this, maybe a subsidiary point, is where a regulator thinks that a case can be dealt with by interim conditions, they really ought to try and specify what kind of conditions might deal with the concern. In this case, it had been argued that conditions could be helpful, but then the tribunal had not been given any assistance in drafting any conditions, and they have fallen into some error when they tried to do it themselves. On the next slide, please. Judicial review. These are just two cases where bodies that have had a role in the fitness to practice process, but are not themselves the regulator, have been held not to be amenable to judicial review, and that's what they're there for. Moving on, please. Procedural fairness, Williams and the GDC. Two points on this case. Firstly, if you are alleging that somebody has not followed the rules or someone's broken the law, the regulator needs to identify with precision what the rules or what the law is, rather than simply alluding to it as what happened in this case. And I know for my part, I've been asked to advise on cases where everyone's convinced that a registrant's not done something that's a statutory obligation. And then when you really drill down to it, people are using the word statutory to mean really serious, as opposed to set out in a specific statute. So I think that's a useful lesson there for us all. The other point in that case, there was dishonesty alleged, and Miss Williams suggested that the dishonesty hadn't been properly put to her in cross-examination, and that was procedurally unfair. The court didn't accept that, and they said in terms of procedural fairness, of course an allegation like dishonesty needs to fairly and squarely be put, but that can be not just through cross-examination, but also the overall way in which the case is presented, so any written statement of case, the opening, and so forth. Moving on to the next slide, which I think is sanction. Yes, that's just an interesting case, I think, particularly for those who defend, where conduct that on the face of it was pretty serious only led to a fairly short suspension with no review. And the GMC did appeal that, and the appeal was dismissed, and that's why I raised that case. I've got one final bonus slide, which is about the PSA. And the reason why I've included this slide is because it deals with matters which aren't so much in reported High Court cases, but which I think are of interest. I'm going to take them out of order because I'm going to deal with them in chronological order. So firstly, Melanie Hayes, that was an NMC case with a nurse who had more than once said some really shockingly, egregiously racist and offensive things, and also said some pretty offensive things about people with mental illness, which was particularly unacceptable because she was a mental health nurse. Her case was disposed of initially by a consensual panel determination. She was given a 12-month suspension, and that was then subject to quite a lot of outrage because it was felt that the racism had not been dealt with sufficiently. The PSA intervened, and the case was then disposed of by way of a further consent order in the High Court, and Miss Hayes was struck off. Now, I do understand that the procedures in the High Court and lots of reasons can point in favour of these things being disposed of by consent, but I would suggest there's some obvious learning points that need to come out from that case, which maybe don't come out so clearly when you don't have a fully reasoned decision of the High Court as to what went wrong and when in that case. Michael Watt, this is an ongoing case in the High Court in Northern Ireland. The PSA have brought an appeal against the NPTS decision to allow his voluntary removal from the register. And as a preliminary matter, the High Court of Northern Ireland has ruled that the PSA essentially doesn't have jurisdiction under Section 29 of its legislation. So that's an interesting case, and I think one to watch. And then finally, the case of Dr. Manjula Arora, another NPTS case, where a doctor had a finding of misconduct and then was subsequently suspended for making some dishonest and misleading statements about whether her agency should have provided her with a laptop. There's been quite a lot of public dismay about that decision, particularly from organisations representing doctors of Indian origin. And it will be interesting to see how that case proceeds. The PSA have themselves put out a statement on it. It doesn't seem like the obvious case where they'd be appealing because something's under prosecution. I don't think anyone's suggesting that case has been under prosecuted, but it would be interesting to see where that one goes. So that's my case law roundup, and I hope it's been helpful. Thank you.
Amy, thank you very much indeed. Now's the time for questions. And if anyone feels they have a question, which they have yet to ask, and wonder whether or not we will be able to deal with it, then please do feel free to type it now, because we only have one. And Amy, it's going to be one for you. So I'll read it out for the benefit of those who can't see the laptop we have in front of us, which is this. I recently had a case where a registrant had not committed a criminal offence and did not have an unconditional discharge, but had appeared in the local magistrates' court and accepted breaching a domestic violence protection order. That's not a criminal offence, but under Section 63 of the Magistrates' Courts Act 1980, it can result in a fine or up to 2 months imprisonment. The regulator pleaded it as misconduct rather than a conviction. Do you agree that was the right approach? Now, I have my own view on that, but yeah. Amy, having provided a case that's come out recently on that, what's your view?
My view is that they couldn't plead it as a conviction because it's not a conviction. And if it's not a conviction, it's not something that is recordable as a conviction, then it's really a breach of a civil order or an injunction. And therefore, it would have to be pleaded as misconduct. So I would say that they are taking the right approach, and there's nothing else that they could do, really.
Well, reassuringly for me, that is entirely consistent with my view. And clearly what comes out of the recent case law, although perhaps in many respects it is a relatively trite approach, one can rely upon that admission as supporting the misconduct that is pleaded. And certainly a failure on behalf of regulators pleading cases to recognise what is a conviction and what is not is something that is not unprecedented.
Can I just make one more point?
Yes,
actually?
please.
Because a lot of regulators, they'll say there's a statutory ground of conviction or caution. We all like to think we know what a conviction is, but when you look into what a caution is, it's actually quite a strange thing. It's not a statutory thing to accept a caution from the police. And if you're looking at a caution from another jurisdiction, so I had a case where it was a Scottish caution, and a Scottish caution is more like a warning. It's not a caution in the sense that it requires someone to accept their liability. And therefore, in that case, I advised that you needed to plead the underlying misconduct rather than rely on the Scottish caution.
That's a very helpful reminder, and I confess that was something I was not aware of. What would be the position where that caution is a protected caution or a protected conviction, and it's only come to light after somebody has made their application for admission to the registrar and not disclosed it?
I think you'd need to look very carefully about how it was protected and what specifically they disclosed and what they didn't.
I don't think there are any more questions. I can't see that any have come through. No, thank you very much, everybody, for attending. As I said at the beginning, to anyone who may not have been here right at the beginning and heard this, the slides and the recording of this webinar will be going out next week. So next week, the slides will be available to all of you who have provided us with your email address as part of signing up to this webinar. And the video itself will be uploaded onto YouTube and the 5 St Andrews Hill YouTube account, which can be accessed very easily indeed. Thank you very much indeed for attending. Have a very good evening.
Thank you.
Bye-bye.